All right. Yeah, this is going to take a bit. So slow down with me. Because if you actually follow the mechanics of what just happened, not the outrage, not the headlines, not the social media noise, you start to see a pattern that's familiar, very familiar. What we're watching right now with Ghislaine Maxwell is not a legal masterstroke. It's a system under pressure, revealing where reality and narrative have diverged too far to stay aligned. Add jailhouse lawyer to the list, convicted child sex trafficker, longtime associate of Jeffrey Epstein, socialite who orbited wealth, intelligence agencies, finance, politics, and yes, someone whose proximity to Donald Trump has been documented for years. Photos, flights, statements, court records. None of that is controversial anymore. It's archived. It's indexed. It's on Wikipedia. It's in Reuters. It's in the New York Times. It's in sworn testimony. And today, exactly as expected, she filed a writ of habeas corpus alone. Pro se. No lawyer. No legal team. No insulation. That detail matters more than people realize. Because her lawyer, David Oscar Marcus, appears to be gone, fired or walked away. Either way, not on the paperwork. And Marcus isn't a lightweight. He's experienced, connected. He understands federal criminal procedure at a level most people never will. So when someone like that exits the frame, you don't assume incompetence. You assume risk, reputational risk, legal risk, ethical risk. I'm speculating, but this is informed speculation. One plausible explanation is simple. He reviewed what Maxwell said under oath to the Department of Justice and realized the story doesn't survive contact with documents, emails, depositions, financial records, Epstein estate disclosures. When your client's narrative collapses under basic verification, the expected value of continuing representation goes negative. At that point, you step away. So now Maxwell is on her own, sitting in a federal prison in Texas with access to a law library and time, a lot of time. And if you've ever seen prison filings written pro se, you recognize the pattern immediately. Overlong, overconfident, selectively correct about legal standards, fundamentally detached from procedural reality. This one is no exception. She was convicted nearly 3 years ago, 12 jurors, unanimous, beyond a reasonable doubt. 5 felony counts tied directly to child sex trafficking. That's not rhetorical framing. That's the legal meaning of the verdict. After conviction, she exercised her appellate rights. That's normal. But here's the key point. Most people miss. She did not argue prosecutorial misconduct. She did not argue jury misconduct. She did not argue judicial bias. Not at trial. Not on appeal. Not at sentencing. Not at the Supreme Court. Her sole argument, all the way up, was procedural. She claimed a non-prosecution agreement Jeffrey Epstein signed in Florida should extend to her in New York. Not that she was innocent. Not that the crimes didn't happen. But that a deal meant for Epstein should function like a legal force field around her. That argument failed. Rejected by the Second Circuit. Rejected at sentencing. Rejected by the Supreme Court. That's usually the end. Until now. Now she files a writ of habeas corpus addressed to a New York judge while she's incarcerated in Texas. That alone is a fatal procedural error. Habeas petitions are venue sensitive. You file where you're confined. This is basic. But let's look at the substance because it's revealing. She claims newly discovered evidence from civil litigation, government disclosures, investigative reports, and documents involving the FBI, banks, and the Epstein estate. She alleges exculpatory evidence was withheld, false testimony presented, material facts misrepresented. She invokes the language of constitutional violation and miscarriage of justice. Here's the problem. Habeas corpus is not a second trial. It's not an undo button. You don't get to raise issues you strategically chose not to raise earlier, especially when you had competent counsel. The law is explicit about this. And she doesn't even address that. She barely mentions her lawyers at all, which is interesting. She resurrects the juror issue. Juror 50, Scotty David, claims bias based on a concealed history of abuse. That issue was already litigated. Judge Allison Nathan examined it, found no influence on the jury. Closed, done, final. She claims suppression of grand jury testimony in violation of Brady. Again, not raised at trial. That alone sinks it. She claims a 25-year pre-indictment delay violated due process. References events from the 1,990 seconds, congressional committees, historical grievances. None of it meets the legal standard. None of it explains why these arguments weren't raised when they mattered. This filing isn't legally serious. Any federal judge will recognize that within minutes. So why file it? Timing. That's the tell. This happens days before potential Epstein document releases. Document survivors have been waiting on for years. Documents the public has been promised. Documents that have already been mishandled, delayed, and politicized. And suddenly, Maxwell injects herself back into the news cycle. She reframes herself as a victim of constitutional injustice. She demands attention. She creates noise. That's not accidental. It's narrative jamming. And then there's the elephant in the room. Pardons, clemency, political leverage. Donald Trump has openly discussed using executive power to reward allies. The Department of Justice is already under scrutiny for how it handled Epstein-related matters during his administration. So you have to ask the uncomfortable question. Is this about law or leverage? Is this a legal strategy or a signaling mechanism? Because we've seen this pattern before. Individuals under pressure attempt to reposition themselves as assets, as potential witnesses, as people who can help or hurt depending on how they're treated. And we know Maxwell has lied. That's not a moral judgment. That's evidentiary fact. After receiving Queen for a Day immunity from Trump's DOJ, portions of her testimony were contradicted by later released emails. Emails from Epstein estate servers, emails showing her real opinions, her real knowledge, her real involvement, including her views on Trump, including her awareness of use, including her role in facilitating access. Those emails exist. They're documented. They're not speculation. She publicly praised Trump.
Very cordial and very kind to me, and I just want to say that I admire his extraordinary achievement in becoming the president now, and I like him, and I've always liked him.
Now, congressional committees want her testimony. She refuses without immunity. That makes sense if you understand incentives. Every word she says risks contradiction. Every contradiction risks perjury. every perjury risk compounds existing exposure. And yeah, if you want to keep tracking how these systems actually behave under stress, take a second, subscribe, share this, and stay connected. Because sunlight is still the best debugging tool we've got. All right. That's it for now.